Recently, the Ohio Medical Board issued a statement regarding the affirmative defense letters in Ohio. Can you, in layman's terms, explain to us what that statement said?
So the guidance that the Ohio State Medical Board put out essentially told doctors that until the State Medical Board finalizes its rules and regulations for purposes of certifying physicians to issue recommendations to patients, that they can be subject to discipline for writing those recommendations. So the State Medical Board has until September of 2017 to write those rules. Effectively, they've told doctors in Ohio not to write recommendations until those rules get written.
And Tom, how is a recommendation different from an affirmative defense letter under House Bill 523?
So they're not that different. The same things that a doctor has to certify in order to recommend medical marijuana to a patient are the same things that a patient has to have included within an affirmative defense letter. That there's a bona fide physician-patient relationship, that the physician has run a 12-month report from the drug database, that the physician has reviewed the risks and benefits of medical marijuana to the patient, and that in the physician's opinion, the benefits outweigh those risks.
So if I'm understanding you correctly, Tom, the affirmative defense letter and the Ohio certification card, those are two different things. Is it necessary for a physician in Ohio to be able to write a certification in order to be able to write an affirmative defense letter?
Yes, yeah, that's my reading of what the State Medical Board has required. Effectively, what they've said is we have an affirmative defense here in Ohio, but patients cannot go to an Ohio doctor to get the certification, the recommendation for purposes of the affirmative defense from a doctor here in Ohio. Effectively, what they've said is you have to go out of state to a different doctor in order to get the certification that you need to invoke the affirmative defense.
So, if an Ohio patient successfully saw a Michigan doctor and was given a Michigan certification, would they then be able to come back to Ohio and get an affirmative defense letter from their Ohio doctor and have it recognized under House Bill 523?
No, because the doctor here in Ohio would have to certify that he or she has reviewed the risks and benefits of medical marijuana to the patient, that the benefits outweigh the risks, all of those things that are included within that letter. If I were a physician here in Ohio, I would be nervous about risking discipline from the State Medical Board by signing my name to any document at this point that would be used by a patient for purposes of an affirmative defense.
Let's say that an Ohio patient goes to Michigan, is certified in Michigan by legally changing their residence to Michigan, which is what you have to do there for it to be legal, obtains an affirmative defense letter from that Michigan doctor as well as a certification, and then is caught in Ohio with cannabis. Is that patient covered under affirmative defense in Ohio?
So the statute was not written to have any difference between somebody who's coming from out of state or somebody who lives in the state of Ohio for purposes of invoking the affirmative defense. The statute simply says that it is an affirmative defense to a charge of possession of marijuana or possession of marijuana paraphernalia if a patient has two things. Number one is a letter from his or her doctor that certifies all of the things we've previously discussed, and that the patient is possessing marijuana or paraphernalia in a form allowed under House Bill 523. So it doesn't differentiate between that person being a Michigan resident or an Ohio resident, but they have to have that piece of paper or the recommendation from the physician that satisfies all of those factors. So the recommendation that you need for the affirmative defense is the same recommendation you need to purchase medical marijuana from a dispensary in Ohio when the system gets up and running.